Welcome to those that are joining us right now. We will probably start at about 12:02, just to give a couple minutes for everyone to join.
Hey, Pam.
Stan, all of our participants, we're going to be starting in about 1 minute. And
Okay.
Stan, you're heard by all of our participants right now.
Okay.
Okay, we're going to go ahead and start. This is Pam Bridge, and I'm joined by Stan Silas, and we are from Community Legal Services. This is part of our lunchtime webinars that we've been doing on different areas of law. Next week on Wednesday, we will be doing how to access the courts in each of the 5 counties that CLS serves. And we will have speakers from each of those counties, and I'll go over those counties in just a second. But the people will be talking from the counties about how to access the courts in those counties. A week from Friday, we will be doing fair housing amid COVID-19. Then the following weeks, we'll be doing special education amid COVID-19. And 2 weeks from Friday, we'll be doing how to deal with air conditioning issues during COVID-19. All of our presentations will be on our CLS YouTube channel, but right now you can find them on the PowerPoints on our CLS website. That's at www.clsaz.org. Okay, so this, just to give you a little bit of background before we start, Stan and I and a couple other staff have been doing these Friday presentations on the governor's executive order and the CARES Act. Last week, our courts issued guidance about the governor's order. So today we're going to focus on that guidance and what it really means. We're not going to go into detail about the exact forms, but we will reference them. So all forms that you can use concerning the governor's order, you can find on our website in English and Spanish. Normally, we've been talking about those forms every week, but if you've been watching those, I don't want to repeat the same things we've been going through. We're really going to focus now on what the court has clarified for us. A couple things. First, our 5 counties that we serve: Mojave, Yavapai, Maricopa, La Paz, and Yuma. So if you are in those counties, you can call our office 8 to 3, Monday through Friday. 602-258-3434 is the main line that goes for all of our counties, and request assistance. legal assistance. As you know, we can give brief advice all the way up to doing direct representation and appearing on behalf of people who qualify in court. However, we can always answer just legal information questions if you qualify for our services or not, if you're in our counties or not, and we are happy to do that. Today, when you have questions, please just write them in our Q&A and we will get to them at the end of this presentation. Okay, before we start talking about the guidance, I just want to remind us what the whole picture looks like right now and include the CARES Act, because as we keep talking about these issues, it really seems to me that we still have people who don't know about the huge protections about the CARES Act. So anytime there is an eviction right now, the first question that everyone should ask is, do the parties participate in a federal subsidized housing program, or does the tenant reside in property that has a federally backed mortgage? As we've discussed before, this is the protection that the CARES Act gives. That is the very first question. You can find a list of those federally subsidized programs that this applies to. It's mainly most of them on our website, like including Section 8, low-income housing tax credit properties. So if the answer is yes, the tenant does reside in these programs or does receive federal assistance, the next question is, are they being evicted for non-payment of rent? Because if they are, the case has to be dismissed. The landlord should not even be filing those cases. And also, another protection is the landlord cannot charge late fees. So before we even get to the governor's order, which talks about the delay of being locked out, you have to look at the CARES Act first, because unlike the governor's order where you can get a judgment against you, the CARES Act says you shouldn't even get that summons and complaint in the first place if it's non-payment of rent. So before we go into the governor's order, I just want to remind everyone of that protection. If you have questions about the CARES Act, we'd be happy to answer it, but this is a huge protection for thousands of our tenants in Arizona right now and throughout the country. So let's talk about the court guidance. It's really focused on the governor's order. First of all, and we're going to go in detail about each of these things. First of all, the court clarified that it's not just for non-payment of rent cases, that the governor's order is not limited to non-payment of rent cases. They clarified that the standard of documents that a tenant has to show their landlord is what's available. They clarified how the landlord should object about this process, and they clarified the length of the delay. So also the court issued best practices at the same time they issued this guidance. And in the best practices, it's meant for Maricopa County. And so in that best practices, they said it applies to mobile homes and RVs also. So as we go through this presentation, anything I have in green is what Maricopa County has said. I'm assuming that the other counties will use this interpretation too, but just know that it was in the, as opposed to the court guidance about what all courts should do. If it's in green, it just means that Maricopa County judges have said that would be in their best practices. Stan, is there anything you want to add to these general things before we get more detail?
No, I think that covers it, Pam.
All right. So we've been talking about this. So what does the tenant have to do to keep themselves by being locked out? As we've discussed before, they have to give their landlord or property manager a notice of any of these COVID-related circumstances and any available documentation. What I've put in red on this on the slide is what the court guidance clarified. First, they clarified that this notice and available documentation can be sent to the landlord or property manager electronically through email or text. You know, we've been telling people that. I've heard judges say that, but it was nice to see that in writing because that's how people are communicating right now. So they clarified that email and text will do. They also stated that tenants must acknowledge that the lease continues. So they're saying that three things have to happen. Number one, the tenant gives the landlord written notice, electronically even, of one of these COVID-related circumstances, that they provide available documentation, and also they made a third, which it does come from the governor's order, that the tenant must acknowledge that the lease continues. Also in the guidance, they suggest that notice be given to the court. However, that is not required, but they are suggesting that that is something that the tenants might want to do. We know that in Yavapai and that in some of our courts where people are appearing in person and not electronically, some tenants are giving that notice to the landlord at the court in person in front of the judge. That's more difficult if it's electronic. You know, the idea is that you want to get it to your landlord as soon as possible. So if you're doing a on the phone hearing, that's going to be difficult. But if some counties throughout the state, if the hearings are happening in person, some tenants are choosing to do it at court in front of the judge. Dan, do you want to add to this?
Yes, I do, because this is very, very important. Pursuant to the governor's executive order and the guidance, you have the tenant, if they believe they have a qualifying COVID-19 circumstance or condition, they have to complete that notice. They have to make sure they give it to the landlord and provide proof that they gave it to the landlord or property manager and any available supporting documentation. And as Pam said, the standard is available supporting documentation. We discussed previously forms we prepared around that issue for those who may need that support through a healthcare provider or their employer. But the key is you must provide that documentation, because in the event that the landlord goes forth with the eviction despite having that information, this is your way of showing to the constable that you have met those qualifying COVID-19 circumstances pursuant to the governor's executive order and the guidance, and therefore you should not be locked out. What this really is about is at the very end, you want to be able to show the constable you've done everything you should do pursuant to the governor's executive order and the guidance, despite the eviction judgment, and that the constable should not lock you out. This is a tenant's way to demonstrate that even though there's a judgment out there, the constable should not execute on the writ. And if you don't take these steps correctly, then you may allow the constable to exercise on the writ and the tenant could be locked out. So it's very important that you follow these instructions, because the guidance makes it clear that that's what you have to do. And then if the landlord wants to challenge it, and Pam's going to get into this, but he or she now has the burden of challenging your claim as a tenant that you should not be locked out.
So, and what Stan said is, and we've talked about this before in our other ones, they're on our PowerPoints and on our website, that we have sample notices you can give your landlord in English and Spanish, sample documentation that you could ask your employer or health professional. And we'll talk a little bit about that, but we have these sample notices on our website. Okay, this is really, really important. The courts clarified that the governor's order does not just apply to non-payment of rent cases. This was really important because there were attorneys looking at that governor's order throughout the state, interpreting it differently. And there were attorneys who believed, just the way it's written, that it only applies to non-payment of rent cases. However, the court's guidance confirmed that that's not true, that it applies to all types of evictions. So normally, non-payment of rent are 5 days, violations of or health and safety violations are 5 days, 10 days are normal violations of your lease. even holdovers, if your landlord does not renew your lease and you stay, and the landlord takes you to court for being a non-renewal of a lease for a holdover, it even applies then. Also, it applies to immediate and irreparable cases. So those immediate cases where you've done something where the courts have said this qualifies as a violation that needs to be out now. So it applies to all of these cases. So in all of these cases, if you have COVID-related circumstances and you give your notice to your landlord with available documentation, you receive this delay. And so, yes, as we've talked about before, you will have a judgment on your record, but the constable will not lock you out. You will have a judgment for any of, if the court finds that you are guilty of the forcible detainer, you could have a judgment for any of these types of violations. But in each of these circumstances, if you follow the right procedure, you will not be locked out of your premises. Stan, you want to add to that?
Yeah, I do. I want to add to that. Here's the point. I was recently in a telephonic hearing for the first time this week with a client. We had negotiated a settlement with the attorney on the other side. So when it was our time to appear telephonically, our case was called. Two attorneys made the notice of appearance. We had already agreed to it, so we went to the back of the line and it's essentially worked it out. But during those telephonic hearings, there are a number of people in that queue. An unrepresented tenant is going to be there by him or herself. What I think is important is he or she is going to have a difficult time during that initial hearing trying to convince the judge that perhaps he or she should have a trial and have another bite at the apple. I believe that there's going to be a certain amount of pressure put on unrepresented tenants in those initial hearings to have it all come out right then and there and resolve it. And I tend to suspect that if they resolve it right then and there in those 5 minutes or so, it's not going to come out favorable for our clients. So as Pam said about these judgments, perhaps despite having this documentation and the notice, they are going to get a judgment against them. And then the only thing that's going to save them from being locked out is they've filled out the forms, the notice correctly, and they have the supporting documentation which they can give to the constable so as not to be locked out. So if you have clients that you know are potentially going to be facing an eviction, if you can assist them preparing for that initial hearing, assist them in making them and demonstrating they have triable issues and they should have a separate trial and not try to jam it in those 5 minutes or 3 minutes, then you want to do that because it's very difficult to have a trial in 3 to 5 minutes with people trying to testify and have some documents available. And the clients are not going to have access to the documents of the other side, nor they're going to have access to the tenant's documents. So if you believe your client has an affirmative defense to the eviction to prevent the judgment in the first place, assist him or her in trying to make that request for a trial or a continuance. Otherwise, those telephonic hearings are probably not the best place for him or her to assert their claim they have valid affirmative defenses.
Okay, so this is one I love. What is the standard of documentation? It's what is available. And so it's still, a little vague, but that's the standard. And why that's important is because before this was clarified, we had cases, there were cases on the news, there were cases at CLS in which a constable might come and basically have a little mini trial right there at the tenant's door, like determining whether what the tenant gave their landlord was enough. So sometimes the constables, some constables would say, well, I'll come back in a week. Let's see if you can get some more stuff. Or let me take your documentation and show it to the landlord and see if they think it's enough. This clarifies that in all of those situations, that's not okay. It's not the constable and it's not the landlord who decide whether the documentation is enough. We're going to tell you what the landlord can do if they believe the documentation was not enough. That they do have a recourse that court set out. But whatever the tenant has, as long as they can show they gave notice to the landlord of a qualifying COVID-related circumstance, any supporting documentation they have, whether it's an email from their employer, a paycheck that shows that they are making less, whatever they have is enough. And so, as we talked about, CLS did create forms that, and Stan and our
Kathy
paralegal
Goodwin.
Kathy created these, which I want to give a shout out to them because I think they're great. But forms tenants can use to show documentation and get from their employer or a medical professional. But I want them, and it's CLS created those forms in English and Spanish to help tenants. But I want to be clear that that's not required. It's what's available. So we understand that pro-per tenants are going to be out there by themselves. And if they have this form, it's going to make the situation easier. But the law, the court's guidance, and the governor's order says they just have to have what's ever available to them. Stan, you want to add to this since you're the creator of these amazing forms?
Well, only that Pam is right. The language is still available supporting documentation. And we have seen situations where people were fortunate enough to get a healthcare provider to actually write an old-fashioned doctor's note disclosing their disability, or an employer to provide documentation that the employee was laid off from his job and suffered an economic loss. Those forms are designed to address those particular circumstances in the governor's executive order to deal with healthcare situations and those that deal with economic disruption situations. But if you're not able to get those forms completed and signed, then again, as Pam said, whatever you have available, that should be enough. The tenant is just going to have to convince the constable, number one, I've got the notice properly completed. I have what's available to me. That's the end of the discussion. If the landlord doesn't like it, the guidance has not provided a route and a remedy for the landlord to challenge the fact that the constable may not execute the writ.
All right, so here we go. What can the landlord do? What recourse does the landlord have? So there's really three situations, recourse that the landlord has. If the landlord thinks that it's in the interest of justice, or the fact that the violation falls under 1368A, which I'll talk about in a second, or they think that that documentation is not enough. They can file, and the courts are calling it a motion to compel enforcement of the writ. It's basically saying that once they get a writ of restitution after a judgment of a tenant, that the constable can lock out the tenant, even if the tenant provided the documentation that we're talking about. So let's talk about for a second, what does interest of justice 33-1368A, what does that look like? Well, 33-1368A lists all the types of violations of a tenant besides non-payment of rent. So it could be a lease violation. It could be also the immediate and irreparable fall there. So it doesn't mean that just because a tenant has a type of violation that the landlord has a right to file the motion and get the tenant out despite the court's order, despite the governor's order. It just means that, let's just say the tenant does have an immediate or irreparable, they did something where the landlord believes that, look, this tenant maybe is a threat to property or other tenants, that it would be in the interest of justice to file a motion that despite having COVID-related circumstances, we can't have them on our property anymore. So it's if they think the situation is that serious that they can't keep the tenant on the property, or they believe that the tenant's documentation is not enough, they could file a motion to compel. So what that means, and now we have in green what the Maricopa County courts in their best practices are kind of spelling out what that looks like. They've decided then if the landlord files this motion, it has to happen within 5 days. the tenant's going to get a copy of that motion. The tenant gets an opportunity to respond. So it's really important that this means that the tenant's going to not only receive a summons and complaint, but they're going to receive a copy of a motion and a court date on the motion. So tenants in their minds usually think there's one court date. Potentially there could be two different court dates where the tenant has to defend themselves on the underlying eviction, and now the tenant's got to defend themselves on the motion. So it's important that we get the word out. The tenants need to look for these two dates. They need to call the courts and find out when that is. So that's something. And also the Maricopa County judges said in their best practices that the landlord files this motion, but then the tenant has to prove by a preponderance of the evidence their COVID-related circumstances. You know, we'd like the opportunity to talk to the Maricopa County courts and like think through that a little bit more, because if it's the landlord's motion, we believe that the burden shouldn't switch to the tenant at that point. But that is what they've said is the best practices at this point. You know, we're hoping for more discussion on that as this gets fleshed out a little bit. Stan, do you want to add anything about this?
I just think that this is, as we said the other day, this is a sort of a messy area because it will lend itself to tenants, as Pam just said, having to go back. First of all, they got to get notice of this hearing, which may be a little tricky because they may be out on the street. If the constable decides he's going to go forward with this thing, they may be out. The constable may decide to go ahead and go forward with it. But the problem is the tenant's got to get notice, and they got to be ready to go back into court telephonically and demonstrate that they have a valid reason for invoking the protection of the governor's executive order under the COVID pandemic. They may need a witness to support that. We don't know. I have not participated in one of these motions at the moment, but we're in the process of getting ready to do something like this probably next week. So this is an area where if you can help your clients, if you find out they're facing a situation like this, they will need all the help they can get. But the most important thing is making sure they get notice of that hearing and being prepared for that hearing and showing up for that hearing. And most likely it'll be telephonic.
We'd love to talk to you. If you know anyone who gets a request for a motion and a court date, we would love to talk to you about that, just because we want to understand what's going on throughout the state on this issue. But again, the Maricopa says that the tenants need to be prepared to show by a preponderance of evidence of COVID circumstances. The other thing that is a concern to us is this also means that potential for attorney's fees and costs, attorney's fees is greater. So if a tenant loses the eviction judgment and loses this motion, potentially they could owe more attorney's fees and their judgment could be even more. So that's just something we need to be watching for. But on the other hand, you know, if there is a tenant who is a threat to other tenants and despite having COVID-related circumstances, if it's a danger for that landlord to keep the tenant on their property, this allows landlords to take action and make sure the courts understand that, yeah, we know there's a health crisis out there, but we believe that there's a threat to our other tenants. So this does give an avenue for landlords to handle this situation.
Let me just add to what Pam's saying, because Pam's done this a long time. I've done it a long time. I'm a little more blunt. This is a situation where it allows people to take advantage of those various sections of 33-1368A and expand upon them. For example, there's what's in the guidance states these are the bases for potentially filing that motion to have the writ executed. Violation of health and safety requirements not related to COVID-19, property damage, criminal activity, or false statements made in the application process. Now, it's hard to imagine what a false statement made in the application process would have to do with an immediate, supposedly an immediate and irreparable breach. But because this governor's order allowed for judgments, but it also prevented the removal of tenants, it is not necessarily something that landlords and property managers are 100% in favor of. So this language allows them to still find a way to obtain a judgment and to obtain a lockout for a tenant. So be vigilant when you see these motions coming, that your clients bring to, or your clients or participants in your programs bring to you, saying this is what's going on, about the truth of the assertions made in those complaints and those allegations, because they may not necessarily be true. So pay some attention to those things and try to assist your clients. The other point I would make is that in those initial hearings, the courts are not always necessarily informing tenants that you have these rights under the governor's executive order. They may be saying, it's out there, go find out for yourself how it helps you. So the reason why CLS and Pam specifically has been pushing this is for you as community partners and agencies. You have to tell your client base, if he or she has a COVID-19 circumstance, they've got to basically represent themselves, because others, landlords and property managers and the justice courts, may not be making people aware that they have these rights. And that's why those forms are so important. They're on our website, to get those in the hands of your clients and have them fill them out completely and fill them out honestly. Don't fabricate this stuff if you don't have those particular COVID-19 circumstances. But if you do, you should take advantage of those protections under the law.
So there are two really good things I'd like to point out too, is that the guidance says that the judges can let tenants know about this order, and that if the judges are permitted and even encouraged to tell tenants about the order, and that if they have these circumstances, they should give notice to the landlord. And it allows constables also to do it. So we've heard of situations where constables have come to the door, and that the constable came to lock out the tenant. Tenant said, I, have underlying conditions like diabetes that make me more susceptible for coronavirus, which is one of the qualifying conditions. The constable in that situation said, well, all you have to do is text your landlord, tell him this with anything you have. And while the constable waited at the door, the landlord did this, texted the landlord, and provided the documentation, and the constable walked away and didn't lock out the tenant. I can't say that's always going to happen, but the guidance made it clear that the constables are allowed to also tell the tenants about this protection, which is really great, because we know a lot of our constables don't want to be in the situation of locking out tenants, especially with the virus. This is another one that I really like. There's a lot of good protection, a lot of good guidance came down, let's just say that. So before this guidance, some constables thought it meant that, like, once a tenant gets a delay, that it only lasts as long as the tenant has the coronavirus circumstance. So they would say, okay, but I'm going to come back in a week and see if you're still sick. I'm going to wait the 14 days of quarantine and come back, and then I'm going to come lock you out. And this makes it clear that that's not the way it should get done. Once you get the delay, the tenant gets to stay until the end of the order, which is July 22nd, or the court orders otherwise. So that would mean that the landlord went in and did one of the motions that we discussed, and the court ordered that the delay would stop. And the guidance says whatever happens first. So this is really important, because that means once that tenant gets a delay, they don't have to be worried about will the constable be coming back next week? When's he coming back? And because they will get a notice of it. They will get notice that from the court that they've ordered that the delay will stop, or they will get notice that there's a motion and a hearing they've got to go fight. But they don't have to worry then about the constable just showing up another day. And this goes until July 22nd. So after the order's over, as we've discussed before, then the tenants can be locked out. Stan, do you want to add to that?
No, I think, but again, that's very important, because it does allow the tenant up until July 22nd to remain in the unit, or if the landlord chooses not to go and challenge the delay in the rent, then they can stay. If they do choose to challenge it, then it's going to depend on the outcome of that motion hearing.
All right. continuances. Just they also said that continuances right now should be liberally granted, especially for everybody at high risk of coronavirus. So if you need to, if someone's sick and you can't do if the telephone or in-person hearing, whatever they're asking, you just cannot show up or not call the court. You've got to call the court ahead of time and tell them that, look, we can't appear then, and tell them why. But you need to reach out to the court if you need a continuance. You can't just assume it's going to happen. But the guidance is to the judges that they should be liberally granted, that's good. That's good news for everybody, for landlords and tenants.
And of course, that is somewhat contrary to the normal practice. So it is great that it's there, because, as I said, that is not traditionally how it takes place in the Justice Court for evictions.
All right, I think that we are reaching our end. Let me see if we have questions. Again, if you're listening right now and you've said, wait a minute, I need some follow-up on this, just give us a Q&A right now and we'll try to address it. Is there any way we can have the PowerPoint presentation? Yes, all of our PowerPoints are on, after our presentations, are posted to our website. Within the next week, I'm going to have all of our PowerPoints translated into Spanish also. So there'll be a Spanish version of all of our PowerPoints also. And we will be uploading all of the webinars themselves on our CLS YouTube channel. So you can go back and see, because especially when we talk about landlord-tenant, we really, in our previous landlord-tenant webinars, went in a lot of detail about the notices, and we spelled out those pretty clearly. So if this is an issue for you, I highly encourage you to look at our previous webinar PowerPoint on that. This is a really good question. Is there any way to find out if a landlord has a federally backed mortgage? So this is a nationwide issue, and I've talked to other attorneys nationwide how, there are a couple of databases you can go on like when you go look at Freddie Mac and Fannie Mae, there's a couple of databases that show properties in certain states that have federally backed mortgages, but not all of them are there. So because it's not an accurate list, I'm not giving it out. The only way to find out if there's a federally backed mortgage clearly is to ask the landlord. What we've been suggesting is for tenants at the hearing on the record, ask the landlord in front of the judge, is this a federally backed mortgage? As we've made clear before, it also applies to all the tenants living in federally subsidized housing programs. And that's way easier to determine because you can look at your lease. And so we've been telling tenants that if you're in a federally subsidized housing program like Section 8 or you're living in low-income housing tax credit, that you make sure if you find yourself at a non-payment of rent hearing in front of a judge, that you tell the judge that you're in that federally subsidized program, and that judge should dismiss it. If you think for even a little bit that there might be a federally backed mortgage on your property, and it's like the numbers are 1/4 to 1/2 of all mortgages are federally backed mortgages. So chances are it may be, if your landlord's paying a mortgage, to ask the landlord on the record. So some people have asked, but why is this protection for tenants? Like, what about that landlord who's got the federally backed mortgage? Are we saying that the tenant can't get evicted for non-payment of rent? Well, the reason the CARES Act has this protection for tenants because it also gave protections for people with federally backed mortgages. If you have a federally backed mortgage, from the time the CARES Act was signed, you cannot have a foreclosure for 60 days. And that's whether you have COVID-related hardship or not. So there was a moratorium on foreclosures for 60 days for all federally backed mortgages beginning the day the CARES Act signed. The other protection that landlords have with federally backed mortgages is that from the date that it was signed, they have 180 days in which they can request a forbearance on their mortgage payment. They just have to go on to their mortgage and online and just attest that they have a COVID-related hardship. Having a tenant who's not paying would be, because of COVID, would be a COVID-related hardship. So this is a huge protection that landlords also have. And I think that's kind of important to make sure, because I know it'll be hard for judges, if they find out that, this tenant's not paying rent, but they can't evict them for non-payment of rent because they're in this federally subsidized program. But it's important to know that the landlords also have protections also. The CARES Act, gave these big things out for tenants and for landlords.
And I would add to that, if you think about it, I understand the question to the equity, but if you're being allowed to forbear, not having to make those huge monthly mortgage payments for 6 months, because that's what 180 days is, that's quite a financial amount of supports being provided to those who are the owners of real property, which offsets the fact that you may have 1 or 2 tenants who are not paying rent in one of your properties. So if the tenants are lucky enough to find out that information, that's a very strong argument to make that those participating in these federal programs, both sides are being treated as fairly as they possibly can by the federal government for participation in these federal programs.
Next question. What to do when the landlord does not want to extend the lease, which ends in June? I am paying my rent. Well, the Landlord Tenant Act besides the CARES Act and the governor's order, everything else under the Landlord Tenant Act continues as is. Each party has the same rights and responsibilities that they had before this. So if your landlord gives you proper notice that they do not want to extend your lease, they can terminate your lease. There is nothing in the CARES Act or the governor's order that would force them to extend their lease. So what would happen if you don't get out at the end of June, then let's say your landlord gave you proper notice that they're not continuing the lease, and then you stayed in your property, and it's assuming that it's private property, not under a federal subsidies program. Then if you stayed, that landlord could take you to court, just as always, get a judgment against you. But at that time, if you had COVID-related hardship or COVID-related circumstances, the governor's order would apply, and that you could, even though you'd get a judgment against you, you could get a delay from being locked out. So what I would suggest in most situations, if you don't want to move and your landlord doesn't want to extend the lease, is to, first of all, keep paying rent no matter what while you're there, like it looks like you're doing. And then second, talk to your landlord and just see if there's any possible way they will agree to continuing your lease. Even just for another 30 days would help. But communication with your landlord is really key. But otherwise, if they give you proper notice, they can terminate your lease.
And if you don't have, yes, because it's in a situation with we are faced with currently for a client. If you don't have that COVID-19 circumstance, then as Pam said, landlord would be permitted to move forward that eviction, obtain a judgment, and remove you from the property. So you would have to be able to demonstrate you have those protections. But if you do have those protections or you qualify for a COVID-related circumstance, you would want to continue, you might want to offer as leverage to negotiate your way out of that situation by saying, instead of staying to July 22nd, I'd be willing to move, say the end of June, if you just give me some more time. This is May, June. I will waive my rights to the full protection if you allow me to stay, and I'll continue paying rent, and we'll do something about the late fees, because you would have that extra protection. You'd have that leverage to stay to the 22nd. If the landlord really wants you out because they want possession, they might be inclined to negotiate and work something out with you.
All right, that is all the questions that we have right now. I just want to remind you that you can always apply for services if you have legal problems. Definitely if you fall under the CARES Act and the federal subsidized program and you're having issues, please call us. But you can always apply for our services. You can also email us just general legal information questions and we can answer those. As long as we're not providing advice, we can provide legal information questions at all times. It says that we were emailed questions previously. I don't have those, but as long as I have an email that I can respond, I will respond to those. I'm sorry about not having those, but I will look for them, and as long as I have an email to respond, I will respond to it. Let me just make sure. Question, is there any big picture work with the Morris Institute of Justice? We've been working really with them, working on the court guidance, and to get all, the question is to get all the sheriff deputies on the same page. Currently, the statewide legal aid offices with the Morris Institute are thinking about ways that we can work with the constables to make sure that we get information out. We just had a big conference call about that last week, and there is a statewide constable, a constable agency. And so yes, we are trying to think about ways that we can work with them to answer any questions, just to be a resource for them and help get the word out. Right, Stan?
Yes, we are definitely, because we recognize that, quite frankly, it was the constables, I believe, down in the Tucson, Pima County area that got this whole thing rolling with the governor for the executive order. And that was unusual for us to see here in Maricopa County. And so, yes, we've been working hard with the Morrison Institute and other legal aid officers to see what would be the next steps to have some communication with the constables, because we should have that dialogue to understand each other and what they're doing, and so as to better effectuate the guiding principles in the governor's executive order.
This is a good question. Can late fees be charged? Late fees can be charged unless you're protected under the CARES Act. So late fees cannot be charged right now until July 25th if you're in any type of federally subsidized program or living in a federally backed mortgage. But otherwise, late fees definitely can continue.
And again, if you're staying in that unit and you're hoping to take advantage of the governor's executive order, then as we said earlier, you need to pay the rent. If they refuse the rent, you need to put it in a bank account someplace. You need to document your efforts to pay that rent, but you clearly must have that money available. So when the governor's order expires or there's no court order seeking to have you removed, you have as much of that money possible as available, because at some point when this protection expires, the landlord will be entitled to all the money on that judgment and all the months of rent that they refuse. And they probably will refuse it because they don't want to get caught up in some other legal situation. So you absolutely cannot spend that rent money. It is not a gift for Christmas. It is something you need on the back end to protect yourself.
This is a really good question. There's 2 July dates to think about, right? So under the governor's order, this whole getting the delay to being locked out, that applies to July 22nd. Because that's when the governor's order ends, July 22nd. Okay, so think about, if the governor's order about getting the delay to being locked out happens until July 22nd. Now, the CARES Act, and that's about the federally subsidized tenants. If we go back to, and the federally backed mortgages, that the CARES Act applies to July 25th. So all the people who are protected under the CARES Act, all those federally subsidized tenants, they cannot receive late fees or be terminated from non-payment of rent until July 25th. So that is, that's why there's 2 different dates. One's for our state. I'm going to go back to our first slide real quick, just because it kind of helps explain that a little bit better. But if you look at the CARES Act is this question up here about the federally subsidized mortgage and housing programs, that their case, that applies to July 25th. All this stuff about once you get a judgment and then not being locked out, that's our state executive order, and that goes to July 22nd. Something we're going to need to think about in July 25th comes along for the CARES Act people is that the CARES Act also says that after that date, the earliest a landlord can terminate your tenancy is with a 30-day notice. So what that means for these federally subsidized tenants, they will have to get a 30-day notice before their lease terminates, even for non-payment of rent. So that's something that we're going to have to figure out in our state when that comes. All right, we're getting lots of questions. I like it. Okay, is a underlying heart disease and being a caregiver for elderly people a protection under COVID-19? Do you want to take this, Dan?
I'll try.
This is wondering whether that is one of the qualifying conditions.
I would say, can I hear the question again, please?
Yes. Wait, I just lost it. Is an underlying heart disease and being a caregiver for elderly people a protection under COVID-19?
I guess I'd have to ask, is the person with the underlying heart condition and a caregiver the person who is a tenant, lessee, and about to lose their housing? From looking at the governor's executive orders, paragraphs 1 through D, perhaps you can demonstrate that heart disease would make your health condition, as defined by the Centers for CDC, as one that makes you more at risk for the COVID-related disease rather than the average person. Caring for those who are elderly or whatever, in and of itself may not be, except perhaps you've contracted the virus and you need to be self-quarantined. That might give you some protections. But I would say the only way I can see that is, as I said, under paragraph 9, that your health condition is such that being exposed, being removed from your home would subject you to being exposed to the virus and be more, would make your health condition more at risk than the average person.
You can go to the CDC website and they list the health conditions that make people more at risk. So all you have to do is just see if it falls there.
And then you might have to supply some available documentation.
I wonder how constables will handle the flood of lockout requests after July 22nd. Does guidance say first time date of eviction? We don't know what July 23rd looks like. We hope that July 23rd does not look like a flood. And I think that's one of the things that the courts, maybe they'll give us more guidance before that date comes, or but basically that would be bad for the entire state, having everybody locked out at once looking for affordable housing at the same time. That doesn't seem like that is the best thing to happen for any of us, right? Dan, do you want to add to that question?
Well, I think it adds to the need for CLS and the other legal aid programs to go have that conversation with constables, because that's an excellent point. No one knows what July 23rd is going to look like. But again, being a practitioner and being a little bit, so we say more aware how this works, I would not be, we don't know how it's going to work, but you can be assured that when landlords have the ability to execute on these writs, they're going to move to execute on them.
The question, going back, the person clarified that the person had the tenant has the heart condition. Again, I would look for that. I would look at the CDC website to see what's listed that makes people, they've defined everything on that website, I believe, that they believe makes people more at risk. And long as you have that, then you should be covered under that COVID-related circumstance.
But you would also need to probably provide some available documentation, be that from your own files, medical records, whatever. But you would have to support that with something that you have that's available to you.
that is what we have right now. And I'll wait one more minute and just do plugs for the next two housings. I mean, I told you what's coming up the next 2 weeks at CLS, but also since this crowd is interested in housing issues, I want to make a plug for our next two housing ones. Next week, Stan and Southwest Fair Housing will be talking about fair housing issues amid COVID-19. And then the week after that, 2 weeks from now, I think this is going to be a really great one, and it's going to be about what to do if your air conditioning breaks down among COVID-19, because there's all kinds of health and things you need to think about. People are concerned whether, do you want maintenance people coming in your house to fix things, if all kinds of questions about how that gets done. There is some guidance on it, and the attorneys will be giving that information 2 weeks from now. Okay, I think that's all the questions that we have right now. I really appreciate everyone who's participating. If you did send a question and we didn't see it or address it here, and you left an email address, we will respond to questions. So I appreciate everyone. Stan, any last words?
No, thank you again. And I would just say that for those who are on the phone, if you represent agencies, community partners, just remember, use those forms on the website for your clients, because they're going to need to demonstrate they have that qualifying COVID-19 circumstance. And despite an eviction judgment, that's the only way the constable is going to be allowed not to lock those individuals out. So you have to help them by getting that information to them and assist them filling out those forms, providing available documentation if you want them to stay in their homes during this pandemic. And I think Pam has done an excellent job of making that point, and she's told you where the information is available on our website. So take advantage of it, please.
All right, we are saying, we've always been asked to remind everybody, keep paying rent. Keep paying rent. So we can say we reminded everybody on this website webinar also. All right, thank you. Please have a good weekend and stay healthy.
Thank you.